APFM, African Parrot Radio. And Yabo and Samba could be released.
Profession etiquette rules. Yes, we drew your attention to it and you were advised to stop, and you did.
My Lord, your Lordship, I no doubt dispute that.
Yeah.
But I think before the proceedings,
I never said you.
Something was said to that.
Oh,
myself and.
Yeah. And
my Lord, if that is the position of the bench, yeah. I'm exceedingly grateful. I don't want my name to be associated with scandalizing the court. As a former president of the Great Akraba, the longest serving president of the Great Akraba,
and the most populous bar.
Yes, and the most populous bar. Yes, Prof, you can call me that. That was conferred on me by the Sanzini Amisha as in custodian of the bar, so I still remain.
And we take this opportunity to also thank you for your end of year dinners for the bar. For the bar and the judges.
So far as that is concerned, Justice Apo can bear ample testimony.
So thank you.
With my eloquent service of blue label Scotch whiskey.
Thank you. Yeah, thank you. This is the order of the court. We accept the apology of learned counsel for the contemnor. We, however, order that the contemnor purges his contempt by retracting the scandalous statement on the very same medium before Thursday, the 25th of February 2021, when the court will reconvene. The contempt proceedings is thus adjourned to Thursday, the 25th February 2021 at 9:30 a.m. So, Mr. Bicham, so you will come here 9:30. If he renders the apology, you will come and completely vacate the order.
My Lord, just for some clarification.
Yes.
I don't believe we are expected to be here on Thursday. No, we just want to be. Yes. Very well.
If you want to come and show solidarity, you are invited, you are at liberty to attend.
So.
Supreme Court at a call. Finally. Judgment, ever on the 4th of March 2021. In 3 weeks' time, and as I said, debut. In 2 weeks' time, judgment, ever. Judgment, the petition, election 2021, and that's election 2020 petition. Ghana BEYEYIE program, African Parrot TV on YouTube. African Parrot TV on YouTube. YouTube. Now you search African Parrot TV. African Parrot TV. Ewa YouTube. We are live. Ewa say fire and it minimum no at the amount. Now young Supreme Court no and Yenya and say 4th of March and a judgment no at the Ebeba contempt. My case, Dr. Anyene Sono. They say, almost say, Uncle retract platform or Gina Swa, or they make key those statements, Uncle retract or retract we are, and maybe Thursday, 25th day of February. Omba, strike out, so contempt cases. 24th of March 2021, and a judgment, the Ebeba. Now, and a review for application, a petitioner, a lawyer, Tatuchikata, Edekotumuno, unanimously, of course, Omasai Abo, Eddie. It is a say, a way and a plane for a plane more, easy chairperson, Jim Mensa, crank to crank, say, Yentimi, Mbisano, questions be. one tia ma me science su bie me ye emfa maw Mrs Jane Adokwe Mensa isi chairperson say Supreme Court rule say yentimi embisa no asembia the oral statement no eno ano no yemfa ne sa yanko tumudifo no yanko omoso Now in 2018, another call Al Jazeera, and I'm beside say, lesbian engaging to Mudifono.
We're not saying that we can, for instance,
I know my decisions. Illegal, our Ghana. Dear dinner, Ebema Abino, ever succumb to the pressure. I say, oh no. Oma mudi trumu ene oma emade omo sase show mo hono illegal wo ye wa Ghana ese se ye chill na on de onyi ye bibisa na nso civil society asori ye e the pressure eto aban no so e ma aban no agi trumu enti Ghana so pressure bia e mai na se pressure eba wan hwa na aban no wagi atum na eno aye 2018 yentie asema Nana Adodan Kwakufo-Addo okafa tumudifo no na yemra sesia aha aye APFM
within our reach. And let me assure that this government has no plans to change the law on same-sex marriage. We have no authority, and we will not seek any authority to do so.
Yentibiem, Nanado, Nensema, or the Atudano, Yentibim, I am Rassia.
Within our reach. And let me assure that this government has no plans to change the law on same-sex marriage. We have no authority, and we will not seek any authority to do so.
Osidabi Ghana same sex yenye yenjin tumuda na anopa ye 1031 ene yenya information bi 1031 ene yenya information Asamede to just say EU European Union omni to mudi from painful bi omo be office e wo Ghana and a statement na abano many age but question me be say won say should we have gotten there na esanka ye du ana esanka ye mom kwan no mu bi omo office ansa na yakọ akọlọke office no ana the second statement Executive Secretary of the National Coalition for Proper Human Sexual Rights and Family Values, lawyer Fosisfo Amoni, says he has information that President Akufo-Addo has directed the closure of the recently opened LGBT office in Accra. Nanado, what director said, EU odi anim say yenko bie to mudi for office no Nanado adawete say yentum eye Nanado why ade but question yenu biye bisa ne say EU an international body say EU European Union on be office our Ghana, the government of the day should be on the node. Yanko Supreme Court yanko the petitioner is addressing the media. Yanko, Nenkoti, and never bought a soft for and never back almost Yanko Supreme Court. Nenkoti
On 16th February, which is a court decision on our application for leave to reopen our case so that we could subpoena the chairperson of the Electoral Commission to testify. Now, for those who are not lawyers, an application for review is a right given to any party dissatisfied with a decision of the Supreme Court to apply to the court and invite the court to respectfully review or change its own decision. And Article 1331 of the 1992 Constitution and the decisions of the Supreme Court has made it clear that you can apply for review of the court decision, and in fact the court will review that decision where there are exceptional circumstances such as fundamental errors of law committed by the court which have occasioned a miscarriage of justice. And so today's application for leave that counsel for the petitioner moved was to achieve just that, to demonstrate to the court that in this decision of 16th February, certain fundamental errors of law were made, and to invite the court to remedy or rectify those errors by reviewing its decision in the interest of justice. Now, the grounds that counsel for the petitioner relied on in moving this application was that, one, you would recall that when counsel was moving the application for leave for the court to allow us to reopen our case, he was asked in what capacity he was seeking to call the chairperson of the first respondent, and he answered by saying that the petitioner was going to call the chairperson of the first respondent, the EC, as an adverse witness. And so you would recall that in the court's decision, the court stated that in their opinion, it was wrong for counsel to have said that he will be calling the chairperson of the first respondent as an adverse witness because per the Black Law Dictionary, a witness can only be described as an adverse witness after the witness has entered the box. And if it is detected during the evidence in chief of that witness that he or she is giving evidence adverse or contrary to the case of the party examining him or her, then that witness becomes an adverse witness, and counsel can then apply to the court to treat the testimony of that witness as that of an adverse witness. That was the decision of the court. Now, ground one of today's application argued that that decision of the court was a clear fundamental error because it did not take into cognizance Section 72 of the Evidence Act. Section 72 of the Evidence Act is simple. It says that subject to the discretion of the courts in a civil action, a party or a person whose relationship to that party makes his interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination. And so, if you are a party or you are a witness or any person and your interest in the case is substantially the same as a party in that case, then an adverse party can call you to give evidence. And so, in our respectful submission that we've made to the court through counsel for the petitioner, one does not have to enter the box before that person can be described as an adverse witness. And that Section 72 of the Evidence Act allows a party to call a person whose interest in the case is substantially the same as another party in that case as an adverse witness. So for us, the court decision for this reason was per incurium. Per incurium basically meaning that it was without recourse or it did not apply this section. And for us, this is a very serious fundamental error because as as the court itself has held in several decisions, the court is the servant of the legislature and must apply the rules or the laws that the legislature, passes. Then secondly, counsel for the petitioner argued the 3E5, we will not apply this. And we, today, counsel for the petitioner respectfully submitted that that was a fundamental error of law. Because number one, Order 38 through 3E5 has got nothing to do with the principle of estupel and a witness or a person being, being held by the court as bound by a previous representation. That order has to do with a party having the right not to call a witness who has already put in a witness statement. The purpose for us relying on Section 26 had nothing to do with the party. It had to do with Jim Mensah as a person. And so for us, that was completely irrelevant. And counsel for the petitioner further argued that even if there was any relationship between Order 38 through 3E5 and Section 26, Order 38 through 3E5 could not be interpreted or construed as having precedence over Section 26, because in the hierarchy of laws, a constitutional instrument is subservient to an act of parliament, and Section 26 is provided for in the Evidence Act, which is an act of parliament and which is superior to Order 38 through 3E5, which is a subsidiary provision made by the Rules of Court Committee. Again, counsel argued that the court did not take cognizance, or the court did not apply Order 38 to the court that he was going to apply should leave be granted for the petitioner to reopen his case. He said, I will follow this rule, Order 38 Rule 10, which is basically the rule or the process for the issuance of a writ of subpoena. And that the court's decision did not make any reference not only to Section 72 of the Evidence Act, but did not also make any reference to Order 38 Rule 10, which we had indicated that we were going to rely on to subpoena Mrs. Jim Mensah. Then he spoke about Article 19.3 and Article 2 with an adjudicating body acting independently, impartially, and ensuring that a case brought before that body, is conducted in line, fairly, in line with a fair hearing. And in our opinion, counsel for the petitioner submitted that if you look at the way the court has failed or refused to apply certain statutes, and the court appears to be shielding, in fact that is in the statement of case, shielding the EC chairperson from accountability or testifying, it is not fair, and it violates the petitioner's right to a fair hearing as stipulated under Article 19 plus 13 of the 1992 Constitution and Article 296. And the question we always ask, which we would like to reiterate today, is that why must we go through all these tedious processes just to get a public officer who pay as citizens of this country, a public officer who has discharged a certain constitutional duty by conducting elections and declaring the outcome of same? We are talking about the events and the returning officer for the 2020 presidential election. Why must we go through all these hassles, all these troubles to get this woman to just give account of her stewardship, how she did her job, and how certain things happened, so that the court can know the truth in these matters and do justice? If she has nothing to hide, if she has done nothing wrong, why must we go through all these tedious processes? Now, there were questions about whether you close your case voluntarily. Yes, we close our case based on the representations of the EC chairperson that she was going to be available for cross-examination. And at the time we were closing our case, we could not have subpoenaed her to testify because she had filed a witness statement and several affidavits which had made it clear that she was going to testify for the first respondent. And so the law and the rules of this court would not have allowed us to even subpoena her at the time. So this issue of you close your case voluntarily, you cannot know. Last time, the president of the bench stated stated clearly that it is a settled principle of law that a party can apply for leave to reopen his or her case after he has closed his case. And that is what we have done, and we believe that we have demonstrated that the circumstances or the conditions which are important for leave to be granted in such circumstances have been demonstrated. The court dismissed this application and said basically that we failed to show the reasons why we were seeking to subpoena Madam Jean Mensah. Now, because of time, I will not go through our statement of case and all that, but you can check paragraph 28 and paragraph 42, and clearly why we need Jean Mensah to enter the box. We explained that she is a returning officer who made a declaration of 9th December. It is she who claims to have made errors. It is her outfit which purportedly sought to rectify that error through unlawful means. It is this same returning officer and her office who have sought to churn out conflicting and inconsistent figures. And that it was important, among other things that we say, it was important that she be made to enter the box, cross-examined, so that the truth in these claims could be unearthed for Ghanaians and the court to appreciate all these things. So we disagree with the court that we did not show why we are seeking to subpoena Jean Mensah and the usefulness of her testimony to the determination of the issues before the court. We believe that the evidence before the court shows that we did that. Again, the court in interpreting section 26, commenting on that, said that there are certain conditions when it comes to promissory estoppel. Now, it's instructive to note that counsel for the second respondent, lawyer Kutampa, had suggested that Jean Mensah didn't even make any representation to us that we could have relied on. And that what Jean Mensah did was basically to state the position of the law that she will be available for cross-examination. That was not a representation, was not an undertaking. Those were his words. Now, the court in this ruling says that it is a representation, but same cannot be said to be unambiguous. In other words, it is ambiguous. We have read those depositions over and over again. Those depositions are undertakings. Per section 26, Jean Mensah is bound by same, and there is no ambiguity in those depositions. She says clearly that the petitioner will not suffer any prejudice or injury because the petitioner can solicit the answers he is seeking through interrogatories during cross-examination. And we believe she meant what she said. Before I conclude, again, the court spoke about section 72 of the Evidence Act that counsel argued on in this case. The court said that there is no inconsistency between the Black Law Dictionary they quoted and section 72. Yet the court still stands by its definition of who an adverse witness is. That, in fact, a person must enter the witness box before he or she can be described as an adverse witness. Clearly, you can all download the Evidence Act 1975 and read section 72 for yourself. It says that, among other things, a person whose relationship to a party makes his interest substantially the same as a party may be called. So you can be called to enter the box as an adverse witness. You need not be in the box before, on the basis of your adverse testimony, you are described as an adverse witness. And so there too we disagree with the court. But ladies and gentlemen, a lot happened today. We do want to bore you with all the details. The bottom line is that the petitioner is worried that the courts in deciding these applications are not applying statutes that have been passed by our parliament and statutes that the court has been applying in other cases. And we think that the petitioner is being denied a fair hearing, and it is important that these issues be pursued to their logical conclusion. Now, why are we doing all these things? We are doing these things because of the constitution that all of us as Ghanaians have agreed to be bound by. Article 63 of that constitution says that no person should be made a president until and unless he attains more than 50% of the total valid votes in any presidential election. And it is clear from Jean Mensah's own declarations and the figures contained therein that candidate Akufo-Addo did not get more than 50%. We've done the mathematics here over and over again, and you can do the mathematics yourself. He did not cross. And so the petitioner, John Dramani Mahama, His Excellency, is doing this for and on behalf of all of us, and is doing this in defense of the Constitution. And so we must all be interested in this case. Let me appreciate those who have been encouraging us and cheering us on. We really appreciate your encouragement. And we are assuring you that we are not giving up, we are not giving in. We are fighting this matter in the interest of justice and for God and country to its logical conclusion. So that tomorrow, an EC chairperson or an EC will not arrogate to themselves the power to choose leaders who have not met the constitutional threshold that we have all agreed to work with. We don't want that bad precedent to be set. The will of the people must always hold sway over the will of a select few. And for those who are crestfallen, those who are discouraged, and sometimes call us worried instead, why don't you withdraw this matter? Why you shouldn't even go to court? We want to tell them that we understand and appreciate your frustrations. We understand and appreciate that. And we are telling you, don't give up. We are not doing this for nothing. We know what we are doing. And we are doing this because of the love we have for Ghana, particularly that of the petitioner. And so let us all be patient with the legal team as we go through the process. We are not abusing the court processes like some are suggesting, and we have not defied the orders of the court. Everybody knows that any party dissatisfied with the decision of the court is entitled to a review. And so we are just using processes provided for under the laws of this country that we have all agreed to be bound by. And let me just say finally, like I said last week, that no matter how this case will go, no matter how the decision will go, because we are all discerning, because we all love the truth, because we are all following this case keenly, the truth will become clear to all of us and we will all see the truth. And don't always think that when people come to court and the applications are dismissed, it means they are wrong. No. What it means is that the court is right for the time being, and it is what the court has said that will prevail. Like now, we disagree with the court, but whether we like it or not, what the court has said is the law, and that is what will prevail. But posterity will be the judge of us all. Just like it happened in the case of Ray Akutu, when the Supreme Court then unanimously dismissed a case brought before it by Joseph Dankwa, J.B. Dankwa, with regards to the unconstitutionality of the Preventive Detention Act. Today, even though the court held the donation oath of the Queen of England and didn't constitute a Bill of Rights and all that, today, what is celebrated is not the court decision. In fact, that is the most unpopular decision in the history of this country, even though it was a unanimous decision. What is celebrated are the submissions of J.B. Dankwa. And we believe that posterity will judge us very well. Will judge us very well. Now, we are hoping, based on the indications that the court has given, that they may find it necessary for counsel to be given the opportunity to make some submissions, oral submissions, on the written submissions they have been asked so far. There's not been any clear indication to that effect that will be done, but the court says that if it finds it necessary, the court will do so. We think that looking at the considerable public interest in this matter, it will be important for that to be done. But if the court, in this wisdom, decides that they are not going to allow counsel to make any oral submissions, we will respect that, and we will be engaging you in the media, and we'll be sharing with you the content of counsel for the petitioner's written submissions. And so this is where we'll end it. If you have any questions, you can ask. Of course, in 2013 it was done. So we are hoping that that precedent, which is a very good precedent, will be repeated in this case.
Right, and the Samuel Fee, your communication director, Edema, as a communication officer, the NDC, the petitioner, honor or address media, FI and Sema, and the see it was Supreme Court. But before so, and to Mr. Oma Kachere, Dr. Anyene, or your spokesperson for the petitioner, said, Uncle render an unqualified apology. Now, on retracting the statement, on render an unqualified apology now or retracting the statement or making say I don't know or determined judgment predetermined judgment say or you senior to the bar and now your former deputy attorney general on retract sa ne statement no samijan fine sama wade tuja ebi ena meka ede achre wono yanko turmudifo no wo kakra me omonsem no ehia me pa turmudifo no turmudifo na anopaye na honorable Kennedy Nyako ose wode betu dwa say LGBTQI office in Ghana has been closed down in orders of President Akufo-Addo in partnership with the leadership of the National Coalition for Proper Human Sexual Rights and Family Values, lawyer Moses Fo Amoni. As a senka yedu ho ana. Yentwen ma omumbie omo office omunya no ansana ya lokia na. Ghana. Uko USA polygamy. Ghana polygamy enye bone no. Polygamy eye bema owale more than one. Bema owale oba more than one. Ghana enye bone. Uko USA eye haram, eye crime. Uko USA turumu enye bone. Enso Ghana eye bone. Bata den na Ghana yatsena ho ama nie eye bone ewo ye kurom no obi ede echechire ye kon aden sika ketua ye benya nti sika ketua bia ye benya nti na saukai time adum so eba ye no Reverend Frimpong Mante no tiem enyansafo ne wahi o enyansafo ne wahi Nyankopon enya politics asem na odi o issues like this ne see ye entia or wipe out Sodom and Gomorrah no eno na nyame ehwehwe se na difo na sofo ebe kasa ewo ho uze tumudifo ne baaye no asofo obi ayedin sese omo na omo kremi nyansafo no obi ayedin Prophet Nigel Gezi emre we na esasa ukasa Reverend Owusu Bempa enye se president we be wini president we be we president we osubin enko na enwuhia emre we na esasa ukasa bedu kobi emre we na esasa mukasa enye se ye Supreme Court Mahama bedin kunim Akufo-Addo bewe Akufo-Addo bedin kunim Mahama bewe eno no efanyankopon ho be Supreme Court asem efanyankopon ho be ye Supreme Court na se obi wi a ebe preventive bakwa ne se man nko heaven ana asofo mo Ghana mi bisamo ye Supreme Court ye Supreme Court na ye bisa asofofo se eba kosisen a ende mutimi ka che se we be wini eno no ebetima nipa a obewe no ebe prevent ne se onko man nko bonsam jem nipa a obe wini no ebe prevent ne se man nko bonsam jem ana se onko heaven eno na nyame ehwehwe ana asofofo am Ghana nye hiamo ano no na monka se we be wini na yema musika turmudifo ana omoji Ghana afa no ende mo yedin ana monka ho asem ende mo yedin Yankopon ohwemo tie mu nyina aka baako dembo na me o say sanse oye Ghana BEYEYIE program ana masuguso amutie 39 minutes past 15 o'clock GMT enche yebe sorry na jumadi akanya no yede atwa APFM yanko YouTube African Parrot TV African Parrot TV. Supreme Court, or some country will be a Sanyameboa 2 weeks time. 4th of March. Judgment, you know. You remember? Judgment, you know. You remember? And date to be 4th of March. Check it. 4th March. Day ni mami. Why? 4th March. Supreme Court election petition 2020 judgment, you know. President of the panel, Chief Justice Eninieboa, or the judgment, you know. Obe ready Ediama Ghana and we are suffering. Into Thursday we are airby ni week. Thursday we are airby ni week. Thursday we are airby utie. Thursday we are airby ni week. And at the judgment, you know. You remember? Kano, I had them. Go and come and young man say, sir, and it's here into 4th March. 4th March. 2 weeks. Judgment, you know. You remember? You do for office now. You be a what test on the side, you know. Nana Adodan Kwaku for the president or see you too. Nana why idea? Me bonsin at the amount. But next time, meant now Emma Ghana for Emma pressure and Sana with this edge man. We send command to radio so anti man Nanado and Kawuntum. Aden, Nana oh mammy swoon no, Oh mammy Dwenindi, oh mammy Titi Musa, adia, as a sanka we see no quino. What can you be? Oh my Ghana for you did this and Sana, a big quatin chair, oh my case, Okrano, Oji Tumudi, a tomb. And so, and yes, sanity, Intinana, next time, no prevention, not that was all me. It has to say, with the Yame, Assam so, now I lock it on office, no. Nana, and ya no quo. Aye, Tumudi for no LGBTQI for no, Omno really we are see you. Aye, Omno Messicano. Omno mu wosika ono mu bobosia enti omesa ne sika kese aba se na naji wei na bi office ne mayen nana menje echirima wo de wo enche obewu 74 years enche obekọ na wo baba wo nana kanso anom ene me ba enhira ono ne ba eba aha omo ene se yetwa kwanpa e de to omo tirim du tirim Bidia no turmudu ade mo amudi turmubia ujan shemo mo amudi turmubia no uja
it was not my intention to scandalize the court
and shemo yanko Supreme Court ai contempt no ne contempt ne che no okasa yanko ne yanko tie
yours sincerely Dr. Dominic Akuruting Ayine signed. And for those of you, I'm sure Mr. Frank Davis is not a stranger to the press. He's standing here to my right. I remember on the 16th of February when I finished addressing the press, he walked up to me and reminded me that the phrase that I had used, that there was a predetermined agenda, had crossed the line. And that is when I started thinking about whether or not I had crossed the line. And I agree absolutely with Mr. Frank Davis and those of you who think that I crossed the line on that day. I wish to unreservedly apologize to the court, that is the Supreme Court of the Republic of Ghana, as well as the justices in particular who sat on that day. There was no intention on my part to impugn their integrity. I was just expressing a sentiment with respect to the ruling of that day. And I want to render an unqualified apology and to retract the words that I used on that day in their entirety. Unreservedly, I will not in any way want to disparage the Supreme Court of the Republic of Ghana. You can see I'm lost for words because I don't want to be, when you want to take a pegative, I was told that I should peg myself of the contempt. So you take the pegative so that you don't complicate the constipation. So I'm being very careful that the prerogative I'm taking this afternoon will not complicate the constipation. And so I wish to thank the press for the opportunity to address you, because His Lordship the Chief Justice, in making the order, said I should use the same medium that are used in conveying the words that are the subject matter of the contempt proceedings. And so thank you very much, ladies and gentlemen of the press. I am hoping that my apology and retraction will be accepted by their lordships, and the matter will come to an end. Now, in respect of this matter, I plead with the press that I won't take any questions and provide any explanations. God bless you and God bless our homeland Ghana.
Aha, enti Dr. Anyene, Dominic Anyene, ena motiano, contempt no echine pa, contempt na chino. Ne kache say baby a ujina ya, obe make those statements say Supreme Court judgment no predetermined no. Onsa me jina ho, pe no onsa on apologize. Inti ya wano ko jina na unim politicians Ghana momanya careful. Mo amoto aba, mo ye political followers. Munya political eaters no. Yawa political followers. Dabi yawa party followers. And yawa party eaters. Party eaters no. Ebene Frank Davids. MPP ni lawyer o jina na nadu echi. Sa asema John Mahama de kwa koto no. Eye hudu rather sem. Dominic Anyene, doctor. Oye NDC ni. Ojina Mr. John Mahama echi. Say some of the court no. And you rather send no kure wom. And ne or render apology no. Say Frank Davis or your MPP ni. Ojina Ninuya Dominic Anyene and Chain and a omo peria singing in Achel. Now what sebe? Wa we party follower. Wa sikay unya bindi. Unya shimfrim. Na woni wunia ekun enye jimie enye bodam ti won politicians yanko na yanko tie the second respondent MPP so amon sema information minister designate Kojo Opon Kroma oka
by counsel for first respondent, counsel for second respondent. I think at the end of the matter, I want to draw your attention to the words of the Supreme Court speaking through His Lordship the Chief Justice in ruling. And I want to focus on that because lawyers express their opinions on the law, what they think the law means, what they think a proper construction of the law ought to mean. And I think today you are noticing that our friends on the other side now keep using the phrase that in our opinion, in our opinion, in our opinion. Initially, the argument was as though it was fact. But you notice that the positions that they were expressing are not supported by the law or the principles of equity. So even a reiteration of it before the press and a re-explanation does not change the fact that the law does not support the position that they've been expressing. And so we will not go into a reiteration of all the legal arguments that we made. I think this is about the third time that the court has dealt with this type of issue and has come to a certain conclusion on it. The court also says that they did not satisfy even the minimum threshold required to sustain an application of this nature. You know, sometimes when we make this point, it appears as though we ourselves are saying it. We are not the ones saying it. The court, I think this is the third time that the court has made the argument that the law does not support their position. They have not met the legal threshold. So we are not the ones saying that what they are saying does not align with the law. For someone to say we are disrespecting our seniors, etc. The court, the Supreme Court of the Republic of Ghana, is the one that is making the point that they have not satisfied even the minimum threshold. So we won't bore you with too much detail. The court has decided that on the 4th of March, judgment should be delivered in this matter. This is after the petitioner who came to court, among other things, arguing that nobody won this election, has called 3 witnesses, and has now, I think in the last 2 or 3 applications, been praying the court to literally force the EC chair into the box so that he can reopen his case and advance something else which he hasn't told the court, something else that can help make a better case for him. The court has decided that despite its earlier warning that if its processes are not complied with, it can strike out the matter, it will still accommodate them so that they can file their written addresses. I think this is clear evidence that nobody's being denied a fair trial here. The court is bent itself backwards and is accommodating the for judgment. So we'll keep it simple. We'll take your questions, and when I'm done, my colleague Nanabi will do a quick tree translation, and then Faisal will do a quick Hausa translation for us. We're going to take your questions.
Right. Wait, I am spokesperson for the second respondent. Projo opponent Kuma. That almost beside said, oh no, or yeah, information minister designate for Ghana, but Supreme Court said Okasa ma why said Ghana na said Nana Akufo-Addo or say Supreme Court he speaks as a spokesperson for the second respondent, not as a minister designate for information. So that distinction was made. Yes. Now, only to different sense of America, me say I am the say Nanado. What to omo? I am a bisamu. I am lawyers no. Oba lawyer. Ah, wo kun ne wo da. O feel when it tie statement a ewie odiaba anapa and grant interview tie human rights lawyer Joyce Opoku Boating na Mr. Boating so tie asem we a obesu mene Mr. Boating me time here no. Human rights lawyer Joyce Opoku Boating has argued that it will be illegal to invade and close down the office of LGBT in Accra. Na me kwa no enye mo say Registrar General or mark to do forward permits say could be office. And no na one until lawyer no can assembly no and one because obi efa kwan paso no be no officer. Wouldn't mean ka say o koloke am robbery illegal e Ghana me boana ai illegal e Ghana and so say am robber for equity permit. I'm not best. Equity permit. That's it. Almost see officer. Who can say about Kobu officer no? Because for the laid down procedure so on a permit in this office. And this person stop on one permit no. Yeah, that's way. Speaking to Morning Star Lantam Papacom, the human rights lawyer said the LGBT people have a right that must be respected. I don't think it would be right for anyone to invade their office and attack them because they have not met there to engage in any sexual activities. Every human being, when you are born, has a fundamental right that no one can take away from you. But we have our norms and culture that frowns upon certain things, she said. However, our checks on the lady have